Vande Mataram. Welcome back to my channel, Courtroom Battles. Dear friends, my name is Dr. TUSHAR MANDLEKAR and I am a practicing advocate in Bombay High Court. This channel is specifically created for the purpose of discussion on law. The Courtroom Battles will elaborate the various judgments passed by the Honorable Supreme Court and the discussion regarding the provisions of the law in this country. If you are a lawyer, or if you are an aspiring lawyer, or a student of law, or has certain interest in law, please join my channel, Courtroom Battles. Whether the common citizen can criticize the judiciary or not, whether there is a freedom of speech to a common citizen to talk about the judgments and the functioning of the Supreme Court or not, whether a fair criticism amounts to contempt of court or not. So the provisions of the Contempt of Courts Act 1971 will have to be seen on the backdrop of applicability of these provisions to the criticism made by the citizens of this country. We are going to discuss the Contempt of Courts Act 1971 today. Dear friends, Indian citizens have received freedom of speech under Article 19(1) of the Constitution of India. The said freedom of speech entitles every citizen to express his opinion. We will have to see whether the power of the Contempt of Courts Act 1971 can be used to curtail such freedom of expression and punish the contemners. In the event if the Supreme Court is criticized by any citizen, whether that criticism amounts to contempt of court, that is a matter of interpretation. The freedom of expression under Article 19(1) is a larger fundamental right available to the citizen of India, but at the same time, that fundamental right is also amenable to the reasonable restrictions under Article 19(2) of the Constitution of India. There is a thin line between the freedom of speech and the contempt. So every court will have to draw that thin line, and if the contemner crosses the line or the border, then he is liable for the punishment. Dear friends, we will have to see the provisions of the Contempt of Courts Act in order to see whether the balancing power of the judge is used in a proper manner or not. Every judge, while punishing the contemner, has to use his power judiciously, and the interpretation of the definition of the contempt will have to be done. There are two types of contempts: civil contempt and criminal contempt. Section 2A of the Contempt of Court Act defines civil contempt. What is civil contempt? Civil contempt means wilful disobedience to any judgment, decree, direction, order, writ or other process of a court, or wilful breach of an undertaking given to the court. In the event if it is found that the judgment, decree or order passed by the Honorable Court is not followed, then the decree holder goes to the court of law and the contemner is punished. But at the same time, willful disobedience will have to be seen. If the order is willfully disobeyed, then only the contemner can be punished. Otherwise, usually it is found and observed that unconditional apology is given by the contemner in the court of law and the contemner is set free. The definition of the criminal contempt is given under Section 2C of the Contempt of Courts Act. Criminal contempt means the publication, whether by words spoken or written, or by signs or by visible representations, or otherwise of any matter, or the doing of any other act whatsoever, which 1. Scandalizes or tends to scandalize, or lowers or tends to lower the authority of any court. 2. Prejudices or interferes or tends to interfere with the due course of any judicial proceeding. 3. Interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. So dear friends, this definition of the Contempt of Courts Act is a very wise definition. The criminal contempt will have to be established, and at the same time, after interpretation of the act done by the contemptor, the punishment can be imposed under section 12 of the act. There are defenses which are available to the alleged contemptor by which he can be saved. Innocent publication and distribution of the matter does not amount to contempt under section 3 of the Contempt of Court Act. Reporting of the court matters under section 4 does not amount to a contempt. So fair reporting of the court cases which is available to the reporters or the news or the print media does not amount to Contempt of Court Act. As per section 5, fair criticism of the Judicial Act does not amount to contempt. The Honorable Supreme Court has stated that when the contemptor transgresses the limit of the fair and bona fide criticism, then it amounts to contempt of court. Ashwini Kumar Ghosh versus Arvind Bose, AIR 1953, Supreme Court 75. But at the same time, whether the criticism is fair or not will have to be decided by the Honorable Court. Under section 6 of the Act, the complaint against the presiding officers of subordinate courts cannot amount to contempt. A person shall not be held guilty of the contempt of court in respect of any statement made by him in good faith concerning the presiding officer of any subordinate court to the higher courts. So if the complaint is filed by a citizen to the higher courts regarding the conduct of the subordinate courts, then it will not amount to contempt of court. Section 10 of the Contempt of Courts Act 1971 empowers the Honorable High Court to punish the contemptor for committing the contempt of a subordinate court. It is found and observed that if the person misbehaves with the subordinate judges or his conduct into the subordinate court is contemptuous, then the contempt petition can be filed under Article 215 of the Constitution of India, read with Section 10 of the Contempt of Court Act 1971 before the Honorable High Court. The Honorable High Court gives the opportunity to the alleged contemptor and then proceeds with the matter. So this is an exceptional power given under Section 10, wherein the subordinate courts and the conduct of the alleged contemptor can be discussed by the High Court. Section 7. Publication of information relating to proceedings in chambers or in camera not amount to contempt except in certain cases. So dear friends, there are exemptions and defenses available under Section 3, 4, 5, 6 and 7. That the question whether the contemptor has committed a contempt or not in accordance with the definition of the Contempt of Courts Act will have to be decided by the Honorable Court. The Honorable High Court has got powers under Article 215 and the Honorable Supreme Court has got powers under Article 129 of the Constitution of India to take appropriate action under Contempt of Courts. Under Section 11 of the Contempt of Courts Act, the High Court has got the powers to punish the contemptor for the offences committed outside its jurisdiction. And under Section 12, the power to actually punish the contemptor is available to the High Court. Under Section 12, the High Court can punish the contemptor jail up to the imprisonment of 6 months or fine up to 2,000 rupees or both. That this power of contempt is a very rare power. And in most of the cases, the contemptor comes up in court of law and renders his unconditional apology and he is let off. But at the same time, the High Court and Supreme Court has not failed in exercising their powers while punishing the contemptors. The freedom of speech which is available to the citizens of this country will have to be used judiciously. At the same time, the High Court and Supreme Court has to interpret the provisions of the Contempt of Courts Act in order to punish the contemptor. Today we are going to discuss certain case laws and the cases by which the Honorable High Court has imposed self-restriction on them while deciding such kind of contempt of court cases. Dear friends, the Honorable Supreme Court of India has adopted restatement of the values of the judicial life on 7th of May 1997. It states that justice must not merely be done, it must also be seen to have been done. The behavior and conduct of the members of the higher judiciary must reform the people's faith in the impartiality of the judiciary. Accordingly, any act of the judge of the Supreme Court or the High Court, whether in official or personal capacity, which erodes the credibility of this perception has to be avoided. There is a self-restriction on the conduct of the judges of the higher judiciary. Dear friends, noted jurist H.M. Sirvai in his book Constitutional Law of the India has stated that scurrilous or abusive attacks on a judge would shake the public confidence and would interfere with the administration of the justice. But the judge who makes public pronouncements which throw a grave doubt on his impartiality himself becomes an offender against the administration of the justice. And since there is no way of setting such a judge right except by the impeachment, the cumbersome procedure seldom resorted to, the interest of justice itself requires that there should be public criticism of the impartiality of the judges. So dear friends, Mr. Sirvai states that there has to be a public criticism of the higher judiciary so as to show them the mirror. A judge who makes extrajudicial pronouncements which show that he lacks impartiality departs from the line of the conduct of his office. Dear friends, at times, if a judge crosses the line and deviates his conduct, then that particular judge also ought to have been seen that he has committed a contempt of court. Dear friends, even judges are not immune from the Contempt of Courts Act. It is very rare that the contempt has been issued and the order is passed against the judge. As we have seen in the case of Justice Karnan, the Honorable Supreme Court has punished Justice Karnan for Contempt of Courts Act. Dear friends, Honorable then Chief Justice Sri Gajendra Gadkar has stated in 1964 that we ought never to forget that the power to punish for the contempt, large as it is, must always be exercised cautiously, wisely, and with the circumcision. Frequent or indiscriminate use of this power in anger or irritation would not help to sustain the dignity or status of the court, but may sometimes affect it adversely. Wise judges never forget that the best way to sustain the dignity and status of their office is to deserve respect from the public at large by the quality of their judgments, the fearlessness, fairness and objectivity of their approach, and by the restraint, dignity and decorum which they observe in their judicial conduct. The judges are always required to maintain the decorum and the dignity of the court. Dear friends, Justice Krishna Iyer in Bharat Kanta Mishra versus Registrar of Orissa High Court 1974 1 SCC 374 has observed, quote unquote, before stating the principles of the law bearing on the facets of the contempt of court raised in this case, he would like to underscore the need to draw the lines clear enough to create confidence in the people that this ancient and inherent power intended to preserve the faith of the public in being public justice will not be so used as to provide public hostility as Outlook, the Star Chamber, a vague and wandering jurisdiction with uncertain frontiers, a sensitive and suspect power to punish vested in the prosecutor, a law which makes it a crime to publish regardless of the truth and public good, and permits a process of brevi manu conviction, may unwittingly trench upon civil liberties, and so the special jurisdiction and jurisprudence bearing on contempt power must be delineated with deliberation and operation with serious circumstances by the higher judicial officers. The High Courts must vigilantly protect free speech even against the judicial umbrage, a delicate but sacred duty whose discharge demands tolerance and detachment of the high power. So Honorable Justice Krishna Iyer has warned the judges to misuse the power. In Ambad versus Attorney General of Trinidad and Tobago 1936, Lord Atkins said, "No wrong is committed by any member of the public who exercises the ordinary right of criticizing in good faith, in private or public, the public act done in the seat of the justice. The path of criticism is a public way. The wrong-headed are permitted to err therein, provided that members of the public abstain from imputing improper motives to those taking part in the administration of the justice and are genuinely exercising a right of criticism and not acting in malice or attempting to impair the administration of the justice. They are immune. Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comments of ordinary men." Dear friends, Lord Atkin said that the case had been discussed and the liberty of the press, which is no more than the liberty of any member of the public to criticize the administration of justice, needs to be respected. The said celebrated judgment of HON'BLE was relied upon in P.N. Duda versus P. Shivshankar, 1988, 3 SCC 167, in which case the law minister was arraigned as a contemner. The Honorable Supreme Court observed, "It is well to remember the observations of the Justice Bremen of US Supreme Court, though made in the context of law of libel in New York Times Company versus L.B. Civilian, that it is a prized privilege to speak one's mind, although not always with perfect good taste, on all public institutions, and this opportunity should be affordable for vigorous advocacy, no less than that abstract of the discussion." Lord Deming, in Regina versus Commissioner of Police of the Metropolis, has observed as follows: "Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity that must rest on sure foundation, nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something far more important at stake. It is no less than the freedom of speech itself. It is the right of the every man, whether in Parliament or out of it, in the press or over the broadcast, to make a fair comment and fairly criticize the judiciary." So dear friends, the fair criticism of the judiciary was welcome. At the same time, Lord Denning has observed that the judges should restrain themselves from taking action or deviating from their own basic duty of delivering justice. The power of the contempt must be used judiciously. Honorable Justice V.K. Iyer, in famous case of S. Mulgaonkar, 1978, 3 SCC 339, says, "The first rule in this branch of contempt power is wise economy of use by the court of this branch of its jurisdiction. The court will act with seriousness and severity where justice is jeopardized by a gross and unfounded attack on the judges, where the attack is calculated to obstruct or destroy the judicial process. The court is willing to ignore by majestic liberalism, trifling and venial offences the dogs may bark. The karwa will pass. The court will not be prompted to act as a result of an easy irritability. Much rather, it shall take notice, look at the conceptus of the features, and be guided by a constellation of constitution and other regards. It is always said that the dogs will bark, but the karwa of the justice will have to pass." The second principle must be to harmonize the constitutional values of the free criticism, the fourth estate included, and the need for a fearless curial process and its presiding functionary, the judge. A happy balance has to be struck, the benefit of the doubt being given generously against the judge, slurring over marginal deviations, but severely providing the supremacy of the law over vicious and unpatterned and malignant contemners, be that the powerful press, gang of the vested interest, veteran columnists, or Olympian establishments are. Not because the judge, the human symbol of a high value, is personally armored by regal privilege, but because, be you the condemner ever so high, the law, the people's expression of the justice, is above you. The curial coverage overpowers the arrogant might, even as the judicial benignity forgives errant or exaggerated critics. Indeed, the fair criticism of a judge needs to be accepted and welcomed, but at the same time, if the serious attack is made on the judiciary, consistently and without any basis, the said attack will have to be done sternly. Judge concerned with the administration of justice would not constitute a contempt. In fact, such fair and reasonable criticism must be encouraged because after all, no one, much less judges, can claim infallibility. So dear friends, Honorable Supreme Court has itself stated that they are also human beings and they are amenable to the errors. A fair criticism of their judgments and their conduct ought to be welcomed. So, the criticism made by a citizen in this country of the judgment of the High Court or Supreme Court or the conduct of the judge needs to be welcomed as per the Supreme Court itself. The Honorable Supreme Court, in a famous constitutional bench judgment of C.S. Kernan in 2017, 7 SCC 1, has observed that the justification for the existence of that is not to afford protection to individual judges. The law of contempt is not made for the protection of the judges who may be sensitive to the winds of the public opinion. Judges are supposed to be men of fortitude, able to thrive in a hardy climate. The object of the discipline enforced by the court in case of contempt of court is not to vindicate the dignity of the court or the person of the judge, but to prevent undue interference with the administration of the justice. Though they do not and should not flow from the power to punish for the contempt, the conduct of the judges needs to be cautious. They should rest or more sure of foundations. The foundations are the trust and confidence of the people that the judiciary is fearless and impartial. The exercise of such power has always been very infrequent and subjected to some discipline. Members of the judiciary have always been conscious of the fact that the power for contempt should be exercised with meticulous care and caution and only in absolutely compelling circumstances warranting its exercise. In para 70 of the judgment of C.S. Kernan, it was observed that the bona fide criticism of the judiciary should be protected and welcomed by the judges, and in a celebrated judgment passed by the Honorable Justice Ranjan Gogoi when he was a judge in Guwahati High Court, 2008 1 GIU LT 800, he observed that judiciary is not oversensitive to criticism. In fact, bona fide criticism is always welcome, perhaps because it opens the doors to self-introspection. Judges are not infallible, they are human beings and they often commit errors, though inadvertently, and because of their individual precedents, it is necessary to welcome such criticism. In such a situation, fair criticism of the viewpoint expressed in a judicial pronouncement or even of other forms of judicial conduct is consistent with public interest and public good that judges are committed to serve and uphold the majesty of the court. Such a realization, which would really enhance the majesty of the rule of the law, will only be possible if the doors of the self-assessment in the light of the opinions of the others and in light of the criticism are kept open by the judges. So dear friends, it is always said that a fair criticism of a judge needs to be welcome. The conduct of the judge also needs to be in consonance with the dignity and majesty he is upholding the post of. The Honorable Supreme Court and the Honorable High Court has to keep in mind that the power of the contempt needs to be very cautiously used. The public opinion and the criticism of the public at large needs to be welcomed. It may happen that the judge may commit a mistake in the court of law, or it may happen that the judgment penned by the judge is erroneous in nature, but the judge has to openly accept his mistake also. So the power of the contempt cannot be used in irritation or in anger. It has to be used very cautiously, and the freedom of the speech given to an individual citizen of this country also needs to be respected. As per Section 15 of the Contempts of Courts Act 1971, the cognizance of the criminal contempt can be taken by the court suo motu or on a motion made by the Advocate General in case of High Court and on a motion made by Attorney General in case of Supreme Court. If the criminal contempt is made out, the opinion of the Advocate General or Attorney General is absolutely necessary. It is found and observed that the High Court and Supreme Court can suo motu also take the criminal contempt and then initiate the proceedings against the contemptor. As per Section 16 of the Contempts of Courts Act, even a judge can be held guilty of the Contempt of Courts Act if he commits a contempt as defined into the Act itself. So even judges are not immune from the action of the Contempt of Courts Act. Justice Karnan is a good example who was punished by the Honorable Supreme Court. Dear friends, so the Contempt of Courts Act gives powers to the honorable judges to punish the contemners. But what is the limitation? The limitation to punish the contemner is 1 year from the date of committing the contempt. So the entire act is specifically framed to determine the difference between the freedom of speech and the contempt of court. Dear friends, in today's era, in the social media, where a lot of public platforms are available, the citizens are openly coming up and criticizing the judiciary. But we as a citizen should also consider that the judges are working in a lot of pressure. They have tremendous burden on them to deliver the justice. There are thousands and millions of cases pending in their courts. So at times, the conduct of the judge may also be unwarranted. But we have to consider that the judges are also human beings. They can also commit the errors. So let us respect the judges and the judiciary of this country. Dear friends, I hope this discussion on the Contempt of Courts Act must enlighten you and your knowledge enhance. If you have liked this video, please press the like button and don't forget to share my channel. Thank you very much. Jai Hind.